Masechet Sanhedrin, Daf Lamed Aleph, and this is the last page in the third perek of the Masechet. Amar Rav Yehuda, Edut hamacheshet zo et zo bebedikot keshera bedine mamonot. When the judges cross-examine the witnesses, they ask them two sets of questions. The first one is called hakirot. That's fundamental questions about when the incident happened, where it happened, the very basic details of what happened. If they contradict each other regarding those basic fundamental details, then for sure we throw out the testimony because, well, if they didn't match up the date even, well then, what are we talking about? There's a rule that in order for testimony to be valid, it has to be falsifiable. In other words, it has to be the possibility that edim zomamim can come and say, no, you were not there on that day because you were with us at the bowl game in Chicago. We saw you there. And if it's not possible to be falsifiable, then we can't trust it. And so that has to do with the fundamental details regarding the time and place. So that's talking about chakirot. That's not what Rav Yehuda is talking about. He's talking about the other set of questions, which is additional questions. What was the person wearing? What color was it? Other things that are incidental. They're not actually a necessary fundamental to the crime itself or the incident alone itself. And in that case, Rav Yehuda teaches that if the two witnesses contradict each other regarding these bidikot, these ancillary details, if it's a monetary case, that's okay. We ignore it because we are less stringent in a monetary case. If it's a capital case and he says, oh, I saw this guy, he was the murderer, here's the time and here's the place. And then we ask them, what is he wearing? And one says white and one says black. If it's a capital case and we say, there's something suspicious here, throw it out. But in a monetary case, we accept it. Amar Rava, mistabera milte de Rav Yehuda be'echad omer b'anneki shechora, ve'echad omer b'anneki levana, aval echad omer maneh shachor ve'echad omer maneh lavan, and mistarfin. Rava now interprets Rav Yehuda in a more limited way to make it a little bit more stringent. And he says, I understand, and it makes sense what Rav Yehuda says. If one witness says that the purse that the lender used when he gave the money to the borrower, one says it was a black purse and the other said it was a white purse. Okay, this is an incidental detail, and remember, it's only men that are the witnesses, and go ask any man, what color was that person's purse, and they're probably not going to remember. And so if they make a mistake about that, then we let it go. We accept the testimony. However, if one of them says that the coin, and the coin that he gave him, some coins are darkened coins, they're black, and some are nice and white and shiny. And so if we ask them, what did the coins look like? One of them says the coins were blackened. The other one says the coins were white and shiny. Then they do not combine. That is an important detail. It's not a basic, when and where it happened. It's not that fundamental. Then for sure, it would not be good. It's still part of bidikot, but it's really an important thing. And if they saw the money, they have to see the money being transferred in order to say there was a loan. And if they saw the money, then they would remember what the money looked like. And therefore, Rava is limiting Rav Yehuda's ruling to only the color of the purse. But the color of the money, that's something essential. Now, this would imply that it's only regarding a capital case, only regarding a monetary case. That's where the incidental, like a black purse or a white purse, is okay. That's because that's what we said, only in a monetary case. But if it was a capital case, then it sounds like Rav Yehuda would say that these incidentals are important. And if someone made a mistake about if he's wearing black or white, then we would throw out the case if it was a capital case. Okay, we question that now. So is this to imply that if someone says a black purse and a white purse, if it was a capital case, then the contradiction would be a problem, and we would throw out the witnesses? ואחד אומר בארירן הרגו, אין זה נכון. אחד אומר כלב שחורים, ואחד אומר כלב לבנים, הרי זה נכון. But look at Rav Chisda, another Amora, said that if it was a murder case and one of the witnesses said it was a sword and the other one says it was an ariran, another kind of sword, maybe a bent sword, something like that, then they do not line up. That's not called congruent testimony. The type of weapon is an essential question, and therefore they have to know what that is, and if they don't, then we throw out the testimony. However, if we ask them, what color was the clothing of the murderer, and one of them says he was wearing black, and one of them says he was wearing white, well then, that's okay, that's congruent, because people don't always remember what color the clothing they're wearing, especially if they're seeing a murder case, they're probably a murder happening in front of them. Maybe they're probably focused on other aspects of the killing and not so much on what the people are wearing. So it's possible for someone to make a mistake. What we see from here is that Rav Chisda thinks that even in a capital case, distinguishing white and black about some incidental item is okay, we let it go. But this is a contradiction to Rav Yehuda, who said only in a monetary case is that okay, in a capital case it's a problem. And so we answer, Gabra Karamit, you're asking about one man against another. Rav Chisda and Rav Yehuda are both Amoraim. And so Rav Yehuda can disagree with Rav Chisda. There's no problem here. So it's a machloket. Okay, so it's not from a Mishnah or a Baraita that they would have to answer. Now the sages from Nehar De'ah, they also disagree with Rav Yehuda, and they say, even if one witness says the coin itself was dark and black, and the other witness says the coins that the lender gave the borrower were white and shiny, they can join together. This is not like an essential question of when it happened or where it happened. A person saw the coin. Do you remember if the dollar bill was crumpled up or if it had a mark on it? Right? You might not pay attention to that, and therefore they do join together. So the sages from Nehar De'ah are much more lenient. If you remember, the last thing we said on the previous daf was also the sages of Nehar De'ah, and they said that you can join together admission after admission, loan after loan, in any combination. And we explained that they follow the opinion of Rabbi Yoshua ben Korcha, who says that you can join together two witnesses even if they talk about two different events. One happened on Sunday, one happened on Monday. That's what we said about the Nehar De'ah yesterday, and now we're going to say the same thing. Keman Rabbi Yoshua ben Korcha. How come you can join together if one said black and one said white? Well, it must be that the sages of Nehar De'ah following Rabbi Yoshua ben Korcha, who says even if the one witness is testifying about an admission or a loan that happened on Sunday, and one about something on Monday, a different transaction altogether, two different loans, you can still join them together as long as the result is that this person owes that person $100. Since they agree on the result, we can join them together. So then that would make sense that the Nehar De'ah following Rabbi Yoshua ben Korcha. However, now we reject this and we say, Emar de shamat led Rabbi Yoshua ben Korcha, hecha de la machachashu ahadadeh, hecha dim chachashe ahadadeh, mi amar, even Rabbi Yoshua ben Korcha only said that you can join testimonies together if they don't contradict each other. But if they contradict each other, would he say you can do that? In other words, if it's talking about two different events, one loan for $100 on Sunday, and the other witness saw another loan for $100 on Monday, they can join together. There's no contradiction there, because it could very well be that the person borrowed money Sunday and also borrowed money on Monday. And the result is the same, that he definitely owes $100 at least, so we can join together to testify that he owes $100. That's okay, because they're not contradicting each other. However, in this case, where they have two witnesses, they're both talking about the very same loan. They both say it was on Sunday, at this time, at this place. And one says the money was white, and others says the coins were black. In that case, they're contradicting each other. So even Rabbi Yoshua ben Korcha may not agree that those two witnesses can join together, and therefore the sages of Nahar De'ah cannot rely on Rabbi Yoshua ben Korcha to say, oh, we're following his opinion. Rather, the sages of Nahar De'ah must be following the following Tana. In the Braita, Amar Rabbi Shimon ben Elazar, Lo nechleku Bet Shammai uBet Hillel al shnei chitei adim, she'achat omeret 200 v'achat omeret maneh, sheyesh bichlal 200 maneh. This is the opinion of Rabbi Shimon ben Elazar, who is interpreting a machloket between Bet Hillel and Bet Shammai. There's different ways to interpret this machloket. We're following this interpretation, and within this interpretation, the sages of Nahar De'ah are going to follow Bet Hillel. So here's what Rabbi Shimon said about this machloket. He said, Bet Shammai and Bet Hillel agree that if you have two sets of two witnesses each, and one set of witnesses, meaning two people, say, we saw this person borrow 200 dinar. And the other set of witnesses, another two people, say, we saw this person borrow 100 dinar. And talking about the same loan, same time, same place. Everybody agrees that it would be acceptable to join them together. We don't need to join them together. We can, there's two witnesses for this and two witnesses for that. Everybody agrees that they don't contradict each other because 100 is subsumed within 200. So there's a common denominator of 100. If they were talking about two different things completely, and one said it was this person, and the other two witnesses it was that person, well then they contradict each other. We have to throw the whole thing out. But here, even though they're saying different things, because one is subsumed within the other, therefore we can accept both sets of testimony for regarding 100, and for sure he would have to pay 100. The second 100, the 200, there that's a contradiction, so he won't have to pay the extra 200. And everybody will agree that this is true because you have two witnesses to the 100 for sure. So the two witnesses, both of the two witnesses can stand alone, and therefore the testimony is acceptable. However, Bet Hillel, Bet Shammai disagree on the following case: al kat ahat. If there's only one set of witnesses, only two people, not four people, but two people. Bet Shammai omrim nechleka edutan, uBet Hillel omrim yesh bichlal 200 maneh. In this case, Bet Shammai says, one witness says, I saw him borrow 200. One witness says, I saw him borrow 100. Well, these are completely different. And so we cannot join single witnesses together to make him pay. Because when it comes to single witnesses, before we can accept them as valid witnesses, they have to be in agreement. They have to be congruent. And if they disagree about some little detail that doesn't matter, okay, maybe that's okay. That was a discussion before. But this is an essential fact, right? How much money did he borrow? If you're going to worry about the color of the money, then for sure you're going to have to worry about the amount of the money. And so if they disagree regarding such a fundamental thing, then we have to throw out their testimony. They're not valid witnesses. This is different from two witnesses that come where the two witnesses agree with each other, the two people, and then so this group is accepted. Once a group is accepted, then the second group that said 200, okay, we're not going to say that they contradict the 100 because 100 is within 200. But that's only because we accepted the group first, so it's a valid testimony. Here, you never had valid testimony to begin with, according to Bet Shammai. According to Bet Hillel, however, says we can apply the same rule even to single witnesses, that although they disagree, and one says 100, one says 200, 100 is subsumed within 200, and therefore we can join them together, 1 plus 1, and have them be a group of valid witnesses. Okay, since Bet Hillel said this regarding 100 and 200, it must be that the Nahar De'ah rabbis are following Bet Hillel in the interpretation of Rabbi Shimon ben Elazar. There are other interpretations, we're not bringing those now. And as follows, if you think that that one witness says 100, one says there was 200, and you accept that, even though it's about fundamentally what they're watching, what they're looking at, and that's okay, it's not called a contradiction, then certainly if the money was black or the money was white, that seems even less important than the amount of the money. And so then the Hadar rabbis can be following the opinion of Bet Hillel within the interpretation of Rabbi Shimon ben Elazar. Echad omer chavit shel yain, v'echad omer chavit shel shemen. Now we have a new case. What if one witness, accepting, let's say, following the rabbis of Nahar there, where if one says 100, one says 200, they can join together because there's a common denominator. What if it's not about the amount of money, but a different type of item? One says, I saw this person borrow a barrel of oil, a barrel of wine. One said a barrel of wine, he owes him a barrel of wine. Now, wine is less expensive than oil. And the other one says a barrel of oil. So would we apply the same thing and say that the value of a barrel of wine, let's say, is $80, is included, subsumed within the value of a barrel of oil? Let's say it's $100. And so he will have to pay $80 worth of oil, or $80 worth of whatever. So would we say the same thing? Or would you say it's completely different? Because here, they're talking about completely different items altogether. What was in the barrel, oil or wine? And maybe that's too much of a contradiction. So let's see. There was a case exactly like this, and Rabbi Ameh was the judge. Rabbi Ameh says you're obligated to pay the value of a barrel of wine out of the barrel of oil. In other words, you have to give $80 worth of oil. So we see that Rabbi Ameh thought that it's the same principle. Whether it's money, the cash value, or an item itself, even if it's different items, if one is subsumed within the other, then we can join the two testimonies together, the two witnesses together, to form a group of valid witnesses. Kiman, who is he following? Rabbi Shimon ben Elazar. So is this following Rabbi Shimon ben Elazar also? Well, Rabbi Shimon ben Elazar, he only told us the example of money, where one says 100, one says 200, and just in terms of numbers, yes, 100 is certainly within 200. That's where he taught us halacha. But would he agree, even in a case where it was a different item, like wine and oil? And the answer is yes, he would agree. La siricha lidmeh. He was only giving that example of money, but the point is it's the monetary value. It doesn't matter if it's actually cash that he gave him or that he gave him some item and it's different items, as long as the value of one is subsumed within the value of the other, which I guess would always be true if it's different values. One smaller one's always within the bigger one, and therefore Rabbi Shimon ben Elazar, in his interpretation of Bet Hillel, would say it doesn't matter if it's actual money or monetary value. Echad omer b'deyota elyona, echad omer b'deyota tachtona, amar Rabbi Chanina, maaseh ba'ad lifnei Rabbi, v'seref edutan. And now a slightly new topic. If one person said, I saw a certain incident happen, it was on the upper floor, the second story of the house. And the other said, I saw this happen, and it was on the first floor of the house. They agree on the other fundamental details of whatever happened, but the exact location. Now, location is important. If one says in one city, one says the other city, then obviously we would throw it out. But this is just within the same house, upstairs or downstairs. Rabbi Chanina said, we had a case just like this that came before the Yehuda Nasi, and he joined the testimonies together. So we see that although location is essential, first floor, second floor is not so important, and you can accept the testimony if they disagree about a slight matter like that. This is the last part of the Mishnah, and we're actually going to quote a Braita now that more or less repeats exactly what the Mishnah said. How do we know that after the verdict is finished and the judges leave the courtroom, they should not say to anyone, certainly not to the litigant, listen, I actually said that you were innocent. I voted for innocence, but what could I do? Because my colleagues, they're the ones that said you're guilty. One should not say that. Rather, they should all exit and speak as one voice. The court said you are guilty, and they should not go and talk about each other. I voted this way, he voted the other way. How do we know? Because the pasuk says one should not be be a talebearer. And the next pasuk in Mishle says, what is a talebearer? Someone who reveals secrets. The deliberations among the judges and the way that they voted, that is a secret. That's supposed to be behind closed doors so that everybody can say whatever is on their mind. And then that's it. Once they give the verdict, it has to be with one voice. And if one of the judges is going to say, listen, I was right, he was, you know what he did, he's the one that put you in jail, so then that would be a talebearer and prohibited. Hahu talmidad nafik ale kala de gale mileta titamar bemidrasha batad asrin vetad ten shenin. And that was a story to show how terrible it is to reveal secrets. There was a student about whom a rumor emerged that he revealed a secret that was said in the Bet Midrash after 22 years. In other words, he kept it a secret for 22 years, and then 22 years later, he told someone, listen, you know what happened one time in the Bet Midrash? Someone said something, whatever it was. We don't know what it is because it's still a secret. But he told a secret 22 years later. And then when it was found out that this student shared this secret, so Rav Ameh kicked him out of the study hall and said, this person is a revealer of secrets. He can't be trusted, and therefore he cannot stay in the Bet Midrash. So you see how serious the burden of keeping a secret is. Okay, if you can keep a secret for a few days, but sometimes you have to keep a secret for many years, even many decades. But that's part of the responsibility of not being a talebearer. The next and last Mishnah of the Perek teaches, anytime a litigant brings proof, he can undo the verdict. In other words, even though the court made a verdict, and then sometime later, even a long time later, one of the litigants says, oh, I found a proof. I have a document, right, that I lost, and now I found it. He can come and bring it to court, and if they accept it, then they will change the verdict. אמר לו, כל ראיות שיש לך הווה מכאן עד 30 יום. מסע בתוך 30 יום סותר, לאחר 30 יום אינו סותר. However, if the judge tells the litigant, listen, any proofs that you have a deadline of 30 days to bring them to court. For some reason, the judge said, maybe he suspects this person, whatever reason, and he says you can only bring it within 30 days. In that case, if he brings it within 30 days, as he finds it and brings it, then they can undo the verdict. However, after 30 days, then the court will not accept it anymore, and we do not change the verdict. So, because the judge said so. But if the judge didn't say anything, that's the resha, that he can bring it at any time, even after 30 days. Amar Rabban Shimon ben Gamliel, ma yaseh zeh shelo masa b'tor 30 umasa la'achar 30. Rabban Shimon ben Gamliel says that's not fair. What should a person do if they didn't find it within 30 days and now they found it after 30 days? Okay, so it's after the deadline, but why should the deadline matter? He has a document, and the document is good proof that he is right. Why should we ignore a valid proof just because it was brought later on? He happened to find it later on, so why should he be penalized for not finding it in time? We should always take it into account. So Rashbag disagrees with Tanakama and says there is no time deadline. Amar lo, have aidim v'amar en li aidim. Amar have re'aya v'amar en li re'aya. Ulachar zeman ebi re'aya u'masa aidim hareze eno kelum. So now the second case of the Mishnah is if the litigant or the judge says, bring witnesses, and the defendant says, I have no witnesses. So he's declaring, I have none, right? This is different from the first case where he didn't say anything, or he said, I have something somewhere, I have to find it. Here, he's declaring, there are no witnesses. The judge tells him, bring some proofs. And he says, there are no proofs. There are no documents that exist. And then, and then after time, all of a sudden, he brings a document in, he brings some proof, or he finds some witnesses. Then we do not accept it because it seems he's lying. First he said, there are no proofs, there are no witnesses. And then when he sees that he's going to lose the case, he probably goes and forges a document or finds some false witnesses. So we suspect that he's lying because he said originally, that there are none. Amar Rabban Shimon ben Gamliel. Rabban Gamliel disagrees about this case also, and he says, "Maya says shelo haya yodea sheyesh lo edim u'masa edim lo haya yodea sheyesh lo re'aya u'masa re'aya." It says, what are we going to do about a person who genuinely didn't know that there were witnesses? He didn't know that there happened to be witnesses in the room when a certain thing happened. They were behind the wall. He didn't see them, and now all of a sudden these people came and they said, "Oh, we were there." So why shouldn't he be able to present it to the court? Or he didn't know that there was some proof, and now all of a sudden he found proof. It's not that he was lying beforehand. He genuinely thought that there was none, and then he's not lying now when he brings this witness or this proof because he just found them. So he really thought that there were none, and now there are. But why should we suspect him just because he may not have known originally that they were there? So Rashbag says we have to accept the witnesses or the proof. Lastly, Ra'ashe mitchayev badin. V'amar kirbu peloni ploni v'aiduni. O she'osiraya metachat pundato. Harezeh eno kelum. However, if right at the time of the verdict, the litigant sees that he's going to be held liable, right? And so now he panics, and all of a sudden he says, "Oh, bring this guy and that guy, and they'll be my witnesses." Or all of a sudden, he pulls out a document from under his belt, and he presents it. So here, everybody would agree, even a bunch of Ben Gamliel would agree, that this is not a proof. You see, he's just doing this out of desperation, because he sees that he's guilty, so he's like, "I gotta get out of this." And then he would be so desperate, he would even bring out something that is not true. Because if he really had the witnesses or really had proof, he wouldn't wait till last minute till he's declared guilty to bring it out. He would bring it right away if it was true. So it must be that he's holding out, because most people, they don't want to lie. They might be caught lying. They don't want to lie in court or bring false witnesses. So they'll wait. So maybe I'll be innocent and I won't have to lie. And then if you say, "Oh no, I'm going to be declared guilty," then you bring out the forged document. So that is too suspect, and everybody agrees that such proof would not be acceptable. Amar Rabba bar Rav Huna, halacha keRabban Shimon ben Gamliel. Amar Rabba bar Rav Huna, and halacha kedivrei chachamim. Now, regarding the first case, when the court makes a deadline of 30 days, Rabba bar Rav Huna, Rabba the son of Rav Huna, says, we followed Rabban Shimon ben Gamliel, and he can bring it even after 30 days. The same sage, Rabba, the son of Rav Huna, also said, we do not follow Chachamim. Chachamim said, 30-day limit, you can't bring it after that. Now we ask, Peshita, the second phrase is redundant. If you tell me that the halacha follows Rabban Shimon ben Gamliel, isn't it obvious that the halacha is not like Chachamim? Why does he say both statements? And the answer is, Aval di'avad shapir dameh kamashmalan di'abid mehaderinan le. If he only said halachas like Rabban Shimon ben Gamliel, I might have thought that's true lechatechila. In other words, a court, someone comes after 30 days, after the deadline, and they bring some proof lechatechila, the court should accept it. However, I might have thought that b'di'avad, let's say the court didn't accept it, and they said, no, it's after 30 days, forget it, we're rejecting it, and we're keeping the previous verdict. I might have thought that b'di'avad, we can follow Chachamim. And that's why he says, no, halacha is not like Chachamim, not in b'di'avad, not even b'di'avad. Even if the court rejected it after 30 days, it's evident that they're wrong. They should not have rejected it, and they have to go back and tell them, "Oh, bring that document back to get back again, and we're going to accept it. And if it's valid, they will change the verdict." Amar lo have edim. Now the second case where the judge says, "Bring witnesses," and he says, I have none. I have no documents either. And then he finds it later. Here also we have the same machloket. Amar Rabban Shimon ben Gamliel, that it's acceptable because maybe he really didn't know that such proof or witnesses existed. Amar Rabba bar Rav Huna, Amar Rabbi Yochanan. And so here, Rabba, the son of Rav Huna, says in the name of Rabbi Yochanan, halacha k'divrei chachamim. So in this case, halacha follows chachamim. He said, I don't have any. So that's it. We assume that was true. He really doesn't have any. And now he's making something up later. V'amar bar Rav Huna, amar Rabbi Yochanan, en halacha k'Rabban Shimon ben Gamliel. The same sage also says halacha is not like Rashbag. So we ask the same question, Pishita. If you tell me that halacha is like Chachamim, kivan damar halacha k'dir Chachamim, mimela yadana de'en halacha k'Rabban Shimon ben Gamliel. Then I couldn't figure out myself that the halacha follows Chachamim, that we do not accept any future testimony that he brings, because he already says I have none. And if I know that, then I know the halacha is not like Rashbag, who says that you can accept such testimony. Hakamash malan debahi en halacha k'Rabban Shimon ben Gamliel, habechuluhu halacha k'Rabban Shimon ben Gamliel. Oh, the second clause teaches us something about other cases. This teaches us that in this case, in the Mishnah, the second clause in the Mishnah, this is where we say that halacha is not like Rabban Shimon ben Gamliel. But we can infer from this statement that in the rest of all of the Mishnah, anytime you see Rabban Shimon ben Gamliel arguing with Chachamim, halacha is like Rabban Shimon ben Gamliel, including in the first case, which we just said, that in the Resha of this Mishnah, halacha is like Rabban Shimon ben Gamliel. That's what we learned from this. So we see that according to Rabbah, the son of Rav Huna, remember this name, halacha is like Rabban Shimon ben Gamliel in all cases except for this, the second case in our Mishnah. This is a little confusing because what we just said in the name of Rav Huna and the name of Rabbi Yochanan will disagree, will exclude that which Rabbah, the son of Hana, said in the name of Rabbi Yochanan. Very similar names, Huna, Hana, but these are different sages. And they're both speaking in the name of Rabbi Yochanan. But there's a disagreement within what Rabbi Yochanan said. And he said, Kol makom sheshana Rabban Shimon ben Gamliel b'mishnatenu, halacha kemoto, chutz me arev v'saidan u're'aya acharona. He said, anytime you see Rabban Shimon ben Gamliel and throughout the Mishnah say something, halacha is like him, except for three cases. The cases are something to do with a guarantor, a case that happened in Saidan with a marriage that was done on condition, a get that was done on condition that you give me this cloak, and she lost the cloak. Can she pay for the value of the cloak and then divorce will kick in or not? That was a machloket, and so halacha follows Rabban Shimon Gamliel in all cases, but not in the case of the guarantor, not in the case of divorce, and not in the case of our Mishnah regarding bringing a proof, acharonat, the second case in our Mishnah, where halacha follows Chachamim. So we see that according to this statement by Rabbi Bar Chana and Rabbi Yochanan, there are three cases where we do not follow Rashbag, whereas in the previous one of Rav Huna in the name of Rabbi Yochanan, there's only one case that does not follow Rashbag. So they both agree that regarding Re'aya Acharona, the second case of our Mishnah, halacha follows Chachamim, and they also agree in all the rest of Shas, and they only disagree in regarding these two cases of Arev and Saidan, where according to Rabba Bar Hana, the halacha does not follow Rashbag in these two cases, whereas according to Rav Huna, in the name of Rabbi Yochanan, halacha does follow Rashbag also in these two cases. And now we have a story relating to this halacha. Hahu yanoka ditba'uhu ledina kamed Rav Nachman. There was a child who was taken to court. Rav Nachman was the judge. Amru le itlach sahadeh amar lehu la. Itlach re'aya amar lehu la. Chayaveh Rav Nachman. And so they asked the child, do you have any witnesses to defend yourself? The child says, no. Do you have any other evidence, any documents? He says, no. And Rav Nachman says, well, then you have to pay. It doesn't tell us the details of what the case was, whatever it was. The child was walking and crying after he heard this news that he has to pay. He's a kid. And so he's crying about the case. Sometimes adults cry if they lose a case too. But the crying helped that it publicized the matter. People heard him crying. They said, oh, what's wrong? What happened? And then some people came and said, oh, we know about your father's business matters, and we can testify about it. So the child didn't know that there's people that know about it. And the people, only when they heard the kid crying, then they said, we know about it, and we can come testify in your defense. Amar Rav Nachman beha, afilu modu afilu Rabbanan modu. Rav Nachman says, in this case, even Rabbanan against Rabban Shimon ben Gamliel will agree that a child was not presumed to know about the business affairs of his father. And therefore, when the child said, I don't know, I don't have any evidence, I don't have any witnesses, he was telling the truth. He really didn't know. And it can't be expected to know about everything that happened. And the fact that he's coming now and saying, oh, wait, I have witnesses, we don't assume he's lying, as Rabbanan usually say. It's true, halacha is like Rabbanan in a usual case where the person is representing his own business affairs and he says, I don't have witnesses. And then all of a sudden he shows up with witnesses. That's suspect, and we do not allow the witnesses to be heard. But if it's a child where he's not expected to know all the business of his father, and he says, no, there's no witnesses, and then someone comes and says, oh, I know about the case, and the child brings them in that case, everybody would agree that that witness is valid. There was a woman who was holding on to a promissory note as a third party on behalf of the borrower and the lender. And she brings it to court and she says, listen, I have this promissory note that I've been holding, says this person owes $100 to that person. But she adds, I also know that this has been paid, so you should not act on the document. So even though she's producing it, she's also providing this information. Rav Nachman said, we should believe her that it was paid. After all, she's the one that brought it to court in the first place. Amar le Rav Nachman keman kerebid amar otiot niknot b'msira. So Rava asked Rav Nachman, who are you following in believing her? Are you following the opinion of Rabbi Yehuda Nasi, who says that letters can be acquired just by transferring? In other words, if I have a promissory note and I want to transfer the ability to collect to you, so if I just give you the document, there's another opinion that says otiyot lo niknot b'msira. According to that, if I hand you the document, all you get is the paper and the ink, but you don't get the content of it. You don't get the right to collect. But Rabbi says that once anyone who transfers, you don't have to do, according to the first opinion, if you want to transfer the debt itself, you have to write another document transferring the contents of this document. But Rabbi Yehuda Nasi says, not necessary. If I just hand you that note, then it's not just the ink and the paper, but also the right to collect is also transferred. So are you following it to be? And that's why you're saying that since this woman has the document, that makes her the legal owner of it. Whoever gave it to her in the first place, that by giving it to her, transfers to her all the power, the right even to collect from the document itself. And therefore, since she is the owner of the debt, if she comes and says this was paid, then we believe her, because any time a litigant themselves admits, oh, I have this document, but it was paid, then certainly we will believe that person. So Rav is asking Rav Nachman, is that what you're relying on? And Rav Nachman says, no, I am not relying on that opinion. I don't necessarily agree with that opinion. Rather, over here, I ruled the way I did because if she wanted, she could have just burnt it. It's not that she necessarily owns the document and owns the right to collect it. That's not necessarily why I'm believing her, but rather because she could just not bring it to court. She could just burn it. She could say, oh, I know this document. This was paid already. Usually, a paid promissory note is destroyed. So she could have just burnt it, and it never would have come to light. And then that would have been over. And the fact that she could have done that, and instead she brings it to court, but says that this has been paid, so she would believe her, because she could have simply never brought it to court in the first place and destroyed it. Okay, that's all one version of that story. Ikadamre la hemna Rav Nachman. But there's another version of the story according to which Rav, same story. A woman brings a document into court, a promissory note, and she said this has been paid. But in this version, Rav Nachman, the judge said, I don't believe you. Thank you for the document. We're going to use the document. We're going to make the person pay. That's named in the promissory note. And we do not believe her to say that it was paid. And now it's Rava that challenges Rav Nachman and says, wait a second, she could have burnt the document, never brought it to court in the first place. And so since she could have burnt it and it would not have been paid, we should believe her when she brings it into court and says it was paid. Why are you not believing her? And the answer is, because it was already ratified in court. The document is not simply a document, it's a ratified document. When someone writes someone else a document, then eventually when that person wants to collect the loan, they bring it to court and the court ratifies the signatures and they write a note on it or attached to it that says this document has been ratified. So then it's collectible. So because this document was already ratified, so we do not say the argument that she could have burnt it, because the fact that it was ratified, now it's a good evidence. And I mean, technically, yes, she could have burnt it, then we wouldn't know about it. But she did bring it. And so it's a ratified document. It's valid to be used. And her statement that I know was paid does not invalidate the document. Itibe Rava leRav Nachman simfon sheyesh alav edim yitkarem behotamav en alav edim v'yasa mitachat yedei shelish o sheyasa achar chitum shetarot kasher alma shelish meheman. Rava challenges Rav Nachman, and this is all in the second version here, where Rav Nachman says, I don't believe the woman. So the challenge is from a Braita that says, if you have a receipt, free receipt of payment about a debt, and the receipt has witnesses on it, then you can ratify it in court, like you ratify any document, and you check to make sure that these signatories, these people really signed it. And then that's it. And you know it was, the payment was received. However, if there are no witnesses on it, but it emerges from a hand of a third party, in that case, we believe it because a third party had it. So obviously they entrusted it to that person. Or if it's, if the receipt is written on the original promissory note, under the signature of the witnesses, after the witnesses says, and this was paid, like a stamp you have today that says paid. In that case, it's valid, and we believe it, and we say that the document was paid. So the challenge is from the third party. According to this Braita, a third party is believed, and since we have this Braita that says a third party is believed, then also the woman is a third party. This loan document was entrusted into her hands, and so just like if she would produce a note that has no signatures, we would trust the note. So too, if she comes and says, here's the document, I know that it was paid, so we should believe her. Tiyufta Rav Nachman tiyufta. And the challenge against Rav Nachman is a conclusive refutation. We could always go back to the first version of it, and who knows, maybe the second version is the original version, and then once it was challenged, then that's how we got to the first version. It says, well, it can't be that he said this because it goes against the Braita, so therefore it must be the first version where he in fact did believe her. כי עתה רב דימי אמר רבי יוחנן, לעולם מביא ראיה וסותר, עד שיסתתם טענותיו ויאמר, קרבו פלוני ופלוני והעידוני. When Rav Dimi came from Eretz Yisrael to Bavel, he reported in the name of Rabbi Yochanan the following statement that is difficult to understand. We're going to have to try to figure out what he meant by it. Anyway, Rabbi Yochanan says that the litigant can always bring other proofs and overturn the previous verdict. He can do that anytime he wants, but until there is a limit, until his claims are stopped. Until that's it. He has no more claims. Do you have any more claims? No more claims. And then he cannot bring them anymore. And he says, then he says, oh, bring this person and that person that they should testify about me. then we don't accept it anymore. In other words, he can bring it as long as he wants. He can take his time, but then once his claims are stopped, no more claims, then he can no longer bring more witnesses. Now we ask, Hagufa kashya. This seems to be self-contradictory. Amat yistatem ta'anotav atan l'rabanan. If you just stopped here, that he can bring any proofs he wants and overturn the verdict until his claims are finished. That is the opinion of Rabbanan. And we follow the opinion of Rabbanan. That's it. Once he said any more, he says no more. Then he can't bring any more. So if you stopped right there, we would say Rabbi Yochanan is following Rabbanan, which makes perfect sense. But then this added phrase, V'adar amaret kirbu ish peloni ufloni v'ya'iduni atan l'Rabban Shimon ben Gamliel. This seems to say the addition that even Rabban Shimon ben Gamliel would agree that if the person, let's say at the time of the verdict, he realizes he's guilty and all of a sudden he says, oh wait, bring these two witnesses. Even Rabban Shimon ben Gamliel is at the end of the Mishnah said, we do not believe him. No, everybody agrees that you would not believe the person in that case. And so it seems from that last line that we're following Rabban Shimon ben Gamliel. You wouldn't have to even add that according to Rabbanan, because even a step before that, Yisatem Tanotav, you can't bring any more. What do you mean Yisatem Tanotav? And you also, and then he says, bring those other people. That sounds like Getz Rashbag. So which one is it? Maybe you can explain it this way. Rabbi Yochanan is following Rashbag completely. And the last line is explaining the line right before that. What does it mean until his claims are stopped? Until he says, bring this person and that person and let them testify for me. In other words, when it says until his claims are stopped, it's not talking about when we ask him, do you have any more witnesses? And he says no. Because according to Rashbag, he can still bring witnesses after that. Because maybe he forgot and he didn't know that he had these witnesses, and now all of a sudden new evidence comes, he can bring that. That's totally fine. So what does it mean when his claims are stopped? When it's at the time of the verdict and he says, all of a sudden, because he realizes he's guilty, he brings these two witnesses. That's when we don't believe him. And the whole thing is in fact Rashbag. However, we just saw that according to Rabbah, the son of Hana, in the name of Rabbi Yochanan, anytime it says the opinion of Rabban Shimon ben Gamliel in our Mishnah, we follow halacha like Rashbag, except for three. And this one, the second case in our Mishnah, regarding proof after the person said, I'm done, I have no more proofs, we follow Chachamim. So it can't be that this is in the name of Rabbi Yochanan, and there's also in the name of Rabbi Yochanan. So Rabbi Yochanan already said halacha is not like Rashbag in this case, so it can't be that his statement means that we're following Rashbag. Elaki ata Rav Shmuel bar Yehuda amar Rabbi Yochanan. So now another student of Rabbi Yochanan, Rav Shmuel bar Yehuda, came from Eretz Yisrael to Bavel, and he explained it. לעולם מביא ראיה וסותר עד שיסתתם טענותיו ויאמרו לו הווה עדים ואומר אין לי עדים, הווה ראיה ואומר אין לי ראיה. So in fact, the person, a litigant, can bring as much evidence as he wants anytime and overturn the verdict. When can he stop? When he has no more claims. That means when they say, bring witnesses, I have no more witnesses. Bring any proofs, I have no more proofs. That's like Chachamim. However, if all of a sudden witnesses come from overseas, so they weren't around, and he didn't think that they were going to come, and he forgot about them. He didn't know they existed, maybe, or he knew that they existed, but that now they weren't here before. He couldn't have brought them before. Or if all of a sudden a saddlebag, or a bag that they would use to store documents was all of a sudden brought to light. A third party had it, that the father of this person had deposited it with that person, and the third party all of a sudden brought it, and so there's documents that he didn't know about. So when he said, I have no documents, he was telling the truth, because he had no idea that these documents would come to light. In that case, even Rabbanan would agree that he can bring them and overturn the case. And that's what it's talking about in the last statement, that he can bring proofs until he says, I have no more proofs, then he can't. unless the last line of Rabbi Yochanan's statement was, unless new witnesses come from overseas or new documents come that were not in his possession before, then that is acceptable. Next, we have another tradition from Rav Dimi in the name of Rabbi Yochanan. Ki ata Rav Dimi amar Rabbi Yochanan, hatokef et chavero badin. אחד אומר נדון כאן, ואחד אומר נלך למקום הוועד, כופין אותו וילך למקום הוועד. If you have someone attacking someone else in judgment, he's suing someone else. And now one of the litigants said, let's go to the local bet din here in our city. And the other one says, no, let's go to the bigger bet din that's in a different city, but it's a more prestigious bet din. Then the one who wants to go to the higher court can force the other one to travel and go to the faraway city that has the more prestigious court. Amar lefanav Rabbi Elazar, Rabbi, mi shenoshe b'chavero maneh, yosi maneh al maneh. So Rabbi Elazar objected to Rabbi Yochanan and said, if someone is claiming a debt from someone else, it's for 100 dinar, now he's going to have to pay another 100 dinar for travel expenses. In other words, if the borrower says, no, I don't want to be judged here, bring me to court over there, and then we'll do it over there. So now this guy, he's trying to collect 100 dinar. By the time he spends money on the travel and lodging and the food and everything, he's going to have to spend 100 dinar, which is what he's trying to collect in the first place. That's not fair. Rather, is the halacha is that the one litigant can say, no, I don't want to travel, and we're staying right here in our local court. So that's the opposite of Rabbi Yochanan. Itmar nameh, amar Rav Safra amar Rabbi Yochanan, shenayim shenit atzemu bedin. Echad omer nadun kan, ve'echad omer nelech l'mkom avad, kofin oto v'dan be'iro. And there is another tradition in the name of Rabbi Yochanan that agrees with Rabbi Elazar, the opposite of what Rav Dimi said. According to Rav Safra in the name of Rabbi Yochanan, if two people are struggling in judgment, and one says, let's go to the local court, and one says, let's go to the larger court that's in a different city, then the litigant that wants to stay nearby wins the day, and he can force the other one to stay in the local court. If the local court doesn't know the answer, no problem, they don't have to travel. They could send a letter to the assembly, to the Bet Havad. Vad is the assembly where the sages gather and discuss. So if it's a high-level question that the local ones don't know, they'll write a letter and they'll get a response, and then the local Bet Din can adjudicate. Ve'im amar kitvu utnuli me'ezetam dantuni kotvin v'notnin lo. And furthermore, if the litigant says, I want you to write down a reason why you judged me in the way you did, then he has a right to ask for that, and the judges will write down their decision and give it to him an explanation of their decision. Because if it's a local court and he's like, I don't trust you guys, you don't seem to know what you're doing, he's entitled to a written explanation. And another halacha, if a woman, her husband dies without children, and so now she wants to do chalitza. So, but let's say she lives in one city, and her brother-in-law, who can do chalitza, lives in another city. She's the one that has to travel to him. She wants to go free and be able to marry, so he's doing this for her. She's the one that has to travel and then and do it in his city. Ad kama amar Rabbi Ameh afilu mitiberia lesipori. How far would she have to go? Rabbi Ameh says, even from Tiberia to Sipori. These cities are not so far away. The point of this statement is that even though the court in Tiberia is more prestigious, and she's in Tiberia, nevertheless, she cannot say, come to Tiberia because it's more prestigious and it's not so far away. No, we don't say that. Rather, we give precedence to that man, and even though he lives in Sipori, which has a lower a court of lower prestige, nevertheless, he can force her. You want chalitza, then you have to come to my city and do it in the court here. Amar Rav Kana, Ma'ikera v'karu lo ziknei ayro v'lo ziknei ayira. Rav Kana says we learn this from the pasuk that says the elders of his city will call him, and this is when it's describing the procedure of chalitza. So it says his city and not her city. That means he can insist that he wants to stay in his city. Amar hilcheta kofino tov yelech limkom va'ad. Amar says the final halacha is that we force him, meaning if one litigant wants to stay in a local place, is back to monetary cases, and the other litigant wants to go to the place of assembly far away, then one can force the other to travel to the higher bet din. Amar le Rav Ashela memar v'ha amar Rabbi Elazar kofino tov v'dan be'iro. So what do you mean? You're saying a halacha is like the original law that Rav Dimi said in the Rabbi Yochanan, but Rabbi Elazar already objected to that and said that no, we force the person that wants to, the person that wants to stay local can force the other one to say no, I don't want to travel. Why should I have to spend more money now? After all, you owe me 100 dinar. I'm going to have to spend 100 dinar just traveling. And so that Rabbi Elazar proved that one can force the other to stay in the local city. So why saying halacha is not like that? And the answer is when do we say Rabbi Elazar says that one can force the other to stay in the local city? That's when it's the borrower telling the lender, hey, I want to go to the Bet HaVa'ad. So then the malveh can say, I don't want to spend money. I'm trying to get 100 dinar from you. And I wouldn't have lent you money in the first place if I knew I would have to travel. And so that's why the malveh can force the loveh to stay in the local city. We're not going to impose on the malveh to have to travel. But the other way around, aval malveh, if the malveh wants to go to a different city, to the higher level court, he wants to make sure that this is done properly, and he doesn't mind, and maybe he goes there anyway, well then the borrower has to follow the lender, because the pasuk says the borrower is a servant to the lender. That's it. The borrower is indebted literally indebted to the lender, and therefore, if the lender wants to stay local, they stay local. If the lender wants to go to a higher court far away, then they go to the higher court far away. Finally, we have one last story about where a certain case would be adjudicated. In this case, it's about whether it would be in Bavel or Eretz Yisrael. So the sages in Eretz Yisrael sent a letter to Mor Ukva, who was the Resh Galuta, the exilarch, the head of the Jewish community in Bavel, which is a very powerful position. And so they gave him a nice greeting that says, Lidzivle kevar bitya shelam, to he who was light upon him like the son of Bitya. And that's referring to Moshe Rabbeinu, who had light upon him. And so they are comparing Mor Ukva to Moshe Rabbeinu, which is a very nice greeting that they are sending him. So they're giving him a lot of honor. So to you who has light upon him like Moshe Rabbeinu, greetings. Ukvan abavli kebal kodamana. And the sages are writing that a man named Ukvan, not related to Ukva, he is a Babylonian. He came before us here in Eretz Yisrael with a legal complaint against Yirmiyah Achi, Ha'avir alayat haderech, against a guy named Yirmiyah. It says his brother. It could be that they're biological brothers and the complaint has something to do with inheritance law, or it could be about something else. It's not clear. Rashi says one opinion, it could be just he stole from me or acted cruelly or injured me in some way. Okay, so anyway, this Ukva came and said he has a complaint about Yirmiyah, and Yirmiyah was in Bavel, and so therefore the writers of the letter tell Mor Ukva ve'imrulo, go and speak to this person Yirmiyah, and hasi'uhu ve'yir'eh panenu beTiberia, and force him to come see our faces in Tiberia, where we have a betin. We want you, Mor Ukva, to please tell this Yirmiyah that he should come and be judged in Tiberia for this suit that Ukvan has brought against him. Okay, now we analyze this letter. Hagufa kasha amart amru lo alma dayanuhu atun. The letter seems self-contradictory. On the one hand, it says, you speak to him, which suggests that they want Mor Ukva to judge the case. Hasi'u v'yir'eh panim b'Tiberia alma shedaruhu hacha. But when it says, tell him to come see our face in Tiberia, that means that they want Morukva to send the litigant to Eretz Yisrael, and he would be judged in Eretz Yisrael. So which one is it? Should he be judged in Bavel under Morukva, or in the Tiberia by the writers of the letter? El hachika amri imrule dainu atun isayit sayit iviila hasiu vire panenu be Tiberia. Rather, this is what they meant when they wrote. At first they said, you speak to him and you judge him, and if he listens to you and you resolve it, good, that'll be fine. But if not, if he won't listen to you and submit to your authority, then send him over here and we will judge it here in Tiberia. In other words, they're giving him both options. You try to do it, and if not, we will take it over. Rav Asher amad dine kenasot hava u'Bavel la dainu dine kenasot v'hadish lachu lehachi kedeh lachalo kavod lemor ukva. Rav Asher says actually it was a case of a fine, and fines can only be adjudicated in Eretz Yisrael where they have official semicha, and not in Bavel where they do not, and so the judges in Bavel do not have the authority to judge fines. And the fact that they told him first, hey, why don't you adjudicate it? They didn't mean it literally. They were just giving him honor. Oh, Mordukva, the great sage, the light that shines upon you like Moshe Rabbeinu, please try to adjudicate it. Now they know that, and he knows that it's a case of fine, so they can't do it in Bavel. They just said that to be nice. But really what they meant is send this guy over to Tiberia so that we can judge him here. Hadran alach ze borer. We will return to you the chapter of ze borer. Chazakim uberuchim. Baruch Adonai leolam. Amen ve'amen.